Okay, everyone, I won't keep you waiting any longer. Welcome to our monthly webinar. This month we are looking at the Employment Rights Bill, having seen some recent changes in it. So by way of introductions, my name's Sam. I'm one of the solicitors here in the employment team, and I'm joined by one of the other solicitors in the employment team, Alice.
Hello.
Before I just dive straight into the webinar itself, a few housekeeping points to begin with. Our webinars are being recorded, and the intention is that we'll be in a position to follow up with you after the webinar to provide both a copy of the slides and also a link to the recording. I anticipate that'll probably either be tomorrow, and if it's not tomorrow, it'll be sometime sort of next week. But we'll get that out to you all. So that if you have any desire to rewatch, recap anything, you'd be in a position to do so. From a general perspective, I think automatically everyone's mics are on mute, and if we keep them that way, it just stops any interference and things like that. But we do welcome any questions and input you may have, and therefore, if you did want to raise a question at any point during the webinar, pop it into the chat function, and then we'll look to sort of pick it up as and when possible, either at the end or possibly even just as we go on during the webinar. In terms of timings today, it is obviously set for an hour. The changes we're looking at are there's a limited number of them. It may well be we fall slightly short of that hour, but again, that will just give some more time to look at some questions if we have some. If for any reason the opposite happens, we run out of time and we don't get a chance to pick all of your questions up, so we can reach out to whoever's asked them directly afterwards as part of any follow-up. So with all of that out of the way, let me provide you with a bit more details on the topic and the webinar itself. So Alice and I are going to be providing you with all the latest news in respect to the Employment Rights Bill. The Employment Rights Bill is a topic that, as a firm, we've covered several times already, and we've had various articles and content as well as done previous webinars on it. And this is because it's the biggest change when it comes to employment law in a generation. Most of people sort of joining us are, likely to be management or HR sort of professionals, and as such appreciate probably the significance of these changes. And it's, I can almost guarantee you, as a firm, this won't be the last webinar and topic we do on it. So as we get closer to implementation dates or as further changes are announced or happen, there'll be more content coming out to keep everyone up to speed on this. During this webinar in particular, though, we're going to firstly be looking at an overview and recap of the journey the Employment Rights Bill has had to date and how we've got to where we are. We will also do an overview of some of the core changes, the core sort of terms even of the Employment Rights Bill at the moment. Alice will then be sort of taking you through an analysis of the recently proposed changes and amendments to the bill, and then we'll finish things off with a review of the implementation date, so when we're expecting these changes to come into effect. So that's the webinar, that's the background. So if we go on then to look at the timeline of the Employment Rights Bill. So you'll see on the slide there's a nice sort of deep visual sort of timeline as to what's happened to date. And the Employment Rights Bill all derives from the Labour's plan to make work pay, which was announced in May 2024. And it was effectively a manifesto document detailing all the promises and proposals and changes they were sort of looking to make in respect of employment and labour laws. Following Labour's election, we then had the King's Speech. And during as part of the King's Speech, there was a pledge to deliver this plan to make work pay within 100 days. So the 100-day plan, and from our end, that set a bit of a timer off and had all of us sort of employment law enthusiasts eager to see, well, what's going to actually happen here? What's going to come to fruition? Because it's going to, it's massive. It's going to have huge impacts to what we do, the advice we're giving, how employees need to be acting and such like. And that 100-day sort of timer saw us through to October. In October 2024, that's when we saw the bill published, and I really got a better idea of what actually things are potentially looking like, what to be expecting, and certainly our end, we were all scrambling around to quickly get up to speed with that, to make sure we were sort of all over the changes. And then it's sort of ambled on since then. There's been a few other sort of proposals and changes as it's made its way through Parliament. And then most recently, between April and June 2025, the House of Lords had their committee stage, which then concluded the end of June, which was then shortly followed by their sort of sitting of the first sitting of the reporting stage in July. And as a result of that, we have seen a number of amendments sort of proposed. Some are government backed, some aren't, but I'm not going to sort of say any more on that at this stage, because that's what the rest of the webinar's for, and that's what Alice will be taking us through. So that's the journey to date. That's how the Employment Rights Bill has come to where it is and where we're currently at. What I felt would be helpful before we go into the actual changes under the Employment Rights Bill is to talk you through some of the core provisions which we're sort of currently are expected. A lot of you are probably already aware of these, perhaps have attended our previous sort of webinars or have done your own reading, etc. So we'll be aware of these. And I want to stress that the changes I'm going to run through here, or the current sort of provisions, they're not the entirety of the provisions of the Employment Rights Bill. That's not the purpose of the webinar today. We're going to be focusing on those, the amendments. But as I say, it's helpful just as a recap for perhaps those that aren't as aware, and also so we, so that we relate to the proposed changes as well, so it's to help just recap in general. But yeah, there's far more changes. We could probably spend an entire webinar, summarising the Employment Rights Bill and the changes and provisions we're expecting. But the core ones. So first up, we have unfair dismissal rights. So the current proposal, so these proposed amendments, the current proposal under the Employment Rights Bill is this introduction of a day one right to unfair dismissal, and that's how it was announced. It was a day one protection against unfair dismissal. Obviously, at the moment, the sort of period of employment before you get that protection is 2 years. Back in December last year, there was sort of a revision to it's just an outright or a clarification to this being a day one protection to introduce its day one rights with something they call an initial period of employment, which was going to be looked at as almost like an enhanced probationary period or similar, where you would be able to still dismiss someone if it was for certain permitted reasons and things such as that. But we'd never have received the full details of that, or how long that will be. It's anticipated it would have been sort of 9 months. So that's the unfair dismissal change, and is probably one of the biggest changes, or certainly those that will impact employers sort of most regularly, and that people need to be aware of, because it'll impact often things like recruitment processes and how employers manage their staff and in probation periods. So that's the unfair dismissal. We've then had restrictions on sort of to fire and rehire practices. Some people refer to it as a ban on fire and rehire. That's not quite what the position is. It is a restriction on it. We've had loads of changes in this space outside of the Employment Rights Bill in recent years. We had the introduction of the Code of Conduct through ACAS, but the latest proposals are looking to effectively make any dismissal of an employee who has refused to agree a variation of their terms automatically unfair, which in itself does appear almost like a tantamount to a ban, because it's saying you can't do it and it'll be automatically unfair dismissal. But there are sort of exceptions, and that's if it's unavoidable effectively due to financial difficulties, i.e. if it's a necessity for the running of the business from a financial perspective. So whilst it's not, it's not a ban, it just stops that process, the fire and rehire process, being abused. But it is a severe restriction on it. We then have introduction of day one rights to paternity, parental and bereavement leave. So currently, for these various rights, you require 26 weeks of qualifying period, so i.e. 26 weeks service. So someone needs to have been employed for a period of 6 months before they were entitled to vote to those rights. So, for example, paternity leave. If someone joined and after 2 months, their partner was giving birth and they were going on wanted to go on paternity leave, it would be at company discretion and would be a sort of company policy as opposed to the statutory entitlement to paternity leave. Now, whilst that's becoming a day one right, what's not being introduced as a day one right is the pay entitlement. That's going to remain at the 26 weeks under this under the Employment Rights Bill. So effectively, they're within that first period. Yes, they'd be entitled to the time off, but it will be unpaid. Again, unless a company or employer discretionarily decides to pay more. We also have the SSP changes, so statutory sick pay becoming a from day one entitlement. What we mean by this is from the first day of any absence period. So again, at the moment, you're required to, so an employee doesn't become entitled to the SSP until they've had a period of 3 days absence. So it's only on that from the 4th day, which they would get to claim and become entitled to SSP. But that's changing, so it's from straight off from the start of the absence. We also have flexible working changes. So again, this is an area that has already changed and developed outside of the Employment Rights Bill in the last year or so. And it's currently a day one right to flexible working. However, their Employment Rights Bill is going to seek to tighten all of this up. And it will make it so employers' refusal of any flexible working requests have to be reasonable. And also the employer has to explain, firstly, the grounds of the refusal. So currently there's 8 effectively permitted grounds, and the employer is going to have to explain which ground it is they're refusing it on, and also why they feel that's reasonable. So it's requires a bit more thought from an employer and setting out really, and it forces them to look into it into more detail as to why are we refusing this, and why can't we do it. On the next slide, we have some further changes as well. We've got the extension of employment tribunal time limits. So generally speaking, at the moment, across the board, most employment tribunal claims have this time limit of 3 months. So, for example, an unfair dismissal claim, you're looking at effectively 3 months from the date of their dismissal for an employee to be able to bring that claim. And they're looking to extend this period to 6 months. That's likely to have the effect, obviously, of an increased number of claims. It leaves a bit more uncertainty for employers, i.e., after certain time frames gone past, you might, think, well, we're in the clear, and that's obviously now just being extended. But as I say, more than anything, I think it will lead to an increase in claims. We then have the extension of the duty to prevent sexual harassment. So again, in recent years, this is recent times, this has changed, and employers have the duty to prevent or to take reasonable steps to prevent sexual harassment. Okay, and the Employment Right Bill is amending this to be all reasonable steps. So it's inserts also a greater degree of the steps required to be taken, and the wider proposal also will see the duty being extended to prevent sexual harassment from third parties. So that could be perhaps from I don't know, customers coming into a workplace, perhaps, or if you've got employees going to premises of clients and things like that, people they're engaging with on that basis. So again, it greatly widens that, puts a bigger onus on employers. And then the final core provision I wanted to cover off was the changes to what we call exploitable 0-hour contracts. And again, there's been some misconception. People have seen this as or said, it's going to ban 0-hour contracts. It's not quite what it does. But what it does, the bill looks to introduce the rights to guaranteed hours based upon average hours over a reference period. We don't know what that reference period will be exactly as of yet. But what that will mean is if you've got someone who is on a, in inverted commas, 0 hour contract, but were regularly working, fairly standardized hours for yourself, they'd adapt this right to guaranteed hours on that basis. It applies to all 0 hour workers, low hour workers, and agency workers as well. And there's some other provisions relating to 0 hour contracts, which will come in as well. Things like a requirement to give reasonable notice for cancellation of shifts, and in absence of the reasonable notice, compensation for any cancelled or sort of curtailed shifts. So that will, we'll see when that all comes in. So that's a bit of a summary of where we are sort of to date, and those core changes, and those summary sort of provisions I've spoken through are the positions that pre any proposed changes. And what I'm going to be handing over to Alice to talk about now is to take you through, well, what are the changes that have been proposed. So all that said, over to yourself, Alice.
Thanks, Sam. So yeah, it has been a whirlwind year for changes, and a bit of a mission, as I'm sure you can appreciate, to keep up with, the various amendments, where we're up to with the bill, the consultations which have sort of been rolling out in terms of the various aspects. And now, like Sam said, on the 14th of July, the first sitting of the bill's report stage took place in the House of Lords. And what we now have is a series of amendments which have been made to the proposals. Some of them are government backed, some of them aren't. And the bill is now going to be returning to the House of Commons. And we then expect it to be subject to, more change, more scrutiny. That being said, we wanted to take you through the sort of key ones, so sort of 6 main areas, as to what is now being proposed and where we stand with these changes which are being put forward. So Sam sort of summarised some of those. So in terms of what it was looking like before the Lords, and I'm going to cover what it now looks like now. So firstly, the changes to 0 hours and low hour workers are the first one that we wanted to cover. As it stands now, the bill gives these workers a right to request guaranteed hours rather than imposing a duty on companies to offer them. So this is a model that came out of the Lords. It essentially has kept the reform as this sort of more structured approach, but has reframed it. So instead of businesses having to proactively offer fixed hours, this revised approach proposes that the workers have the right to request them instead. Now, in terms of eligibility, as it's currently looking, the right applies to request these hours if a worker averages at least 8 hours a week over a 26-week reference period. And although the mechanism for how to actually make these requests isn't yet specified, we're expecting this to follow in secondary legislation. Now, there's also a predictable work element to this and to these proposals. So companies must give reasonable notice of shifts and cancellation of those shifts within a 48-hour window. So if you're looking to cancel on very short notice, then that would trigger the right for the worker to claim compensation. This 48-hour marker was sort of battled around in the Lords and was explicitly discussed, and the 48-hour window is where we currently stand. Now, in terms of status, these proposals and these provisions are government backed and have survived the Lord's scrutiny, albeit that these have been converted to a request regime instead of a guaranteed sort of offer. And what we're expecting is these to phase in from 2026 to 2027 as per the government's delivery roadmap. So turning to unfair dismissal then, like Sam said, the government's position is still to remove this 2-year qualifying period, deep breaths, and deliver day one unfair dismissal rights to then be supported by this probationary type framework, the initial period of employment, which I'm sure you will all be very well versed in what that might look like now. Instead, the Lords have voted for a 6-month qualifying period and to drop this initial period structure. So a lesser period than the 2 years as we currently know it. So rather than this day one right plus probation. The Lords have backed this amendment by 304 votes to 160, but it hasn't been backed by the government. So this is certainly one to look out for when the bill returns to the Commons for, you know, further consideration. I think this one is one of the ones which is going to be subject to a lot of scrutiny and a lot of backwards and forwards on this front. We are expecting the Commons to hold the line and in terms of where it currently stands on day one rights with this probation sort of element, initial period element, whatever we want to call it, in line with their manifesto. And although the media continues to highlight employer concerns about, increased costs, litigation risks, that doesn't appear to be changing the government's stance to it. So that's what we're expecting. We're expecting them to stand firm on that. It will be a key area of political debate, given the potential impact on tribunal volumes as a result of it becoming a day one right. It's going to be, tribunals, as I'm sure many of you will be aware, are subject to a monumental backlog, and this is going to, this is likely to increase the number of claims that come in, as well as, impacting employer flexibility in terms of operationally how this looks to work in practice. But for now, I'd say, we'll be watching this space in terms of what happens with the Lords' proposal versus what the government is standing firm on. Next up, we wanted to look at where we are up to in terms of the proposals to NDAs in harassment and sort of discrimination type situations. So the government has explicitly backed an NDA clampdown, and this change was added in a series of sort of late amendments, but now sits firmly within the proposals that we are expecting to come in. Essentially, any clause in a settlement agreement or an employment contract that prevents current or former workers from either alleging or disclosing work-related harassment or discrimination will be void. So this covers employment contracts, it covers settlement agreements, and doesn't just cover the disclosures in and of themselves, but will also extend to how the employer responds to those allegations. So a huge change here in what currently provisions can, cover up and, settle out. And there's lots to be thinking about in terms of updating your standard form contracts, so updating the employment contracts, or updating your standard settlement agreements to ensure that they will be compliant with these new provisions that come in. Now, there are exclusions for reasonable adjustments and also victimisation. Those have been these sort of limitations and carve-outs to NDAs haven't been extended to those, and we will need to wait for regulations to clarify what counts as an accepted agreement, because equally the ban doesn't apply to those. We are expecting to have more detail, as and when that comes through. A common theme and a common thread through all of these proposals, in sort of their original form and also in the Lords, is that things will be covered in secondary legislation. Things will be subject to consultation and further clarification. Equally, it looks like employers can still use NDAs to protect, their trade secrets and, commercial confidential information. In terms of status and where these stand then, there continues to be debate in the press about the consequences of these changes, but the direction of travel is set. These are government-backed measures, so we do expect them to come in on or shortly after the bill is passed. So this is certainly one to flag to get contracts and things updated to make sure that they're going to be compliant as and when they come in.
And I think Sorry,
Sorry,
Alice,
Dan.
just cut in. I just think this is
Yeah.
such a major change, and another impact. I think if this one comes into place, we'll see. It is in relation, unless they carve anything out under the accepted agreements with settlement agreements, because for an employer, at the end of the day, you know, part of often claims that might be being settled relate to discrimination, and I think the difficulty they have is the part of the incentive of the settlement is probably the confidential nature. So it's really going to impact perhaps the willingness, I think, of some employers to be entering into settlement agreements or settling discrimination claims, you know, with that incentive in mind, because it still doesn't affect things being reported and being out there, which, you know, it's cross purposes at the end of the day. And there's good reason for the introductions of this, but it's certainly going to have that wider impact.
Yeah, definitely. And I think as well, sorry, that ties into, you know, how there's an extension of duties, there's extension to harassment. So I think with where employees are going to have more rights in terms of those claims, coupled with the fact that they're now limiting the ability of settlement agreements to, you know, sort of settle those types of claims, we're going to need to be adjusting processes and really training up within organisations so that we're having less of those issues, I guess. To get
it's never a bad space to be in.
Yeah, exactly.
Better to avoid them than have to settle them, obviously.
Yes, yeah. So turning to whistleblowing, and in terms of, you know, what is new here. So the Lords have also proposed amendments on whistleblowing. Now, these are not government backed, and I think are probably unlikely to be passed, but we wanted to cover them to give you a full insight nonetheless. So the headline aspects of the proposals are that the definition of qualifying disclosure has been broadened. So they're proposing that qualifying disclosures now cover mismanagement of public funds and also abuse of authority, plus a regulation making power to add further categories to that. The disclosure must be in the public interest. So currently, obviously, it's reasonable belief that the disclosure is in the public interest. What the Lord's proposing is a higher bar than the current requirements, so a higher test to meet. So we're looking at, you know, the removal of that reasonable belief aspect. The Lords have also proposed the creation of an Office of the Whistleblower as an independent channel to deal with disclosures which would help, you know, support and implement these things if they came in. And they've also proposed financial penalties. So in a retaliation type situation to when someone does blow the whistle, individuals could be fined up to 10% of their gross annual income, which is capped at 50k. And also employers can face fines of, if these are passed, of up to 10% of the annual global turnover. So, you know, there's potentially huge financial liability there if that did get passed. Now, obviously, the status of these proposals is uncertain, and there's a significant chance of them being reduced back or removed in the Commons. The government has backed these changes, and you know, they've cited proportionality concerns for employers. So we may see these, you know, stripped out when the bill comes back to the Commons, and we're all watching what on earth happens to these proposals. So it's an uncertain status, but it is certainly one to sort of keep an eye out of, just because of the potential, you know, financial impact and the potential change in terms of, you know, how we're operating under whistleblowing, under the whistleblowing regime. So turning to fire and rehire then. Now, these are government-backed proposals, but have been softened when the bill made it up to the House of Lords. So, like Sam said, originally the fire and rehire provisions were drafted very broadly, so pretty much catching almost any attempt to impose contractual changes by dismissing and re-engagement, with a strict, you know, checklist for employers to follow. Like in terms of what that would have looked like, or under the current proposals, that makes most fire and rehire scenarios almost impossible, except in, extreme cases to prevent a total business collapse. Like, that is the sort of level of bar that we're looking at. Now, the Lords have narrowed this down, so it only applies to restricted variations. So variations in terms of pay, hours, and pensions. And the checklist has gone and it's been replaced by a reasonableness test. And there is a new automatic unfair dismissal rule. In terms of this sort of the new automatic unfair dismissal element, this is where agency staff are used as replacements. So under the revised proposals, where employees are dismissed and replaced with either, self-employed contractors, workers who aren't employees, agency workers, all of those type of workers to do substantially the same work as the employee was doing originally, then those dismissals would be automatically unfair. That being said, there is a defence to this. So employers in genuinely, calamitous financial distress still have a defence. So employers can defend the fire and rehire where serious financial difficulty leaves no reasonable alternative. So there's that reasonableness element coming in, but obviously there is still changes there. Now, while the government remains, behind the reform, it has been significantly diluted during the bill's passage going through. And again, we'll just watch this space, but we're expecting that these will go through and we will be, keeping an eye out for the specific thresholds to be refined in terms of whether there's other elements added in and other scenarios or, a refinement of those. Nonetheless, we are expecting these changes will take effect in October 2026. So sort of one of the ones that's going to be a forerunner of those. Lastly, then, turning to statutory leave. So statutory leave has been, a key area and a real focus of the amendments and the provisions under the Employment Rights Bill. As Sam mentioned earlier, there's a series of changes in relation to those. You'll see on the slide that we've set out two main proposals. So we've got proposals to statutory sick pay, that's SSP, and bereavement leave that were put through and their status. So in terms of SSP, the Lords have floated a rebate scheme for SMEs to reimburse costs effectively, but this hasn't been government backed. What their proposal looks like it would have done is, shifted some of the financial burden back to the state, but the government has made it clear that, this is unlikely to be supported on the grounds of affordability. In terms of bereavement leave, now this has been extended to include stillbirth or loss of a child within the first 24 weeks of pregnancy. This has been accepted by the government, and we should see detailed follow in consultations that come out across the next year or so. In terms of where this leaves us then, in terms of these two sort of main areas, we're expecting the bereavement extension to proceed. But in terms of the statutory sick pay rebates, I think it's unlikely to survive the Commons, as is a lot of the current theme here. But we will watch and keep our eye out if that does change, or if when it goes back to scrutiny, whether it looks like it will be introduced, and we will obviously keep you updated. Thanks, Sam. That is all from me. So hopefully that gives you an idea of, where we're currently up to pre the bill going back to the House of Commons for this sort of ping-ponging around.
Brilliant. Thank you, Alice. So yeah, they are the changes that sort of have come out of the sort of House Lords Committee and reporting stages. The other sort of recent amendment as such, or changes and news in this space, was on the 1st of July, sort of last month. We saw the implementation roadmap announced, and this is something we'd sort of been waiting for in many respects, because we need to know when on earth all of this is going to happen. And this is obviously, like with everything, and you're probably all going to be sick of Alice and I saying this, it's subject to change, but it's the position as we currently know it. And for all of our sakes, fortunately, it's not this, upon assent of the bill, this is all coming into place at once. I think, certainly as employment lawyers, I think our heads would explode with what we'd sort of suddenly be having to do with the questions that come at us. So in many respects, it's a good thing. These things sort of spread out. It gives employers the opportunity to, prepare, really get their heads around the changes that are coming at each stage, and adjust as they need to. And as I've said, that they remain subject to consultation and changes. But as of today, this is the position, and there is certainly some, other sort of changes that will come into place which aren't captured in this list, but again, I've sort of selected, like we did at the start, the sort of core ones that most generally will impact on employers and organisations. So the first round of sort of core changes will be in April 2026, which is a time we're always used to change from an employment law perspective. It's always in April we see things like, statutory rates of pay for sick pay or minimum wage and things like that increasing. So it sort of ties in nicely with the normal yearly changes. And the first of these is the collective redundancy protective award increase. It's not a change I sort of summarised or touched on earlier, but effectively, when we're looking at sort of the requirements on employers in sort of collective redundancy processes, if an employer falls foul of their duties and obligations there, it can give rise to a protective award for each employee, which currently sits at 90 days. So in essence, circa 3 months pay. So it's already quite a weighty penalty, and the Employment Rights Bill seeks to double that. So we'll be seeing 180 days, i.e. closer to 6 months pay per employee. So obviously that is significant, as you can see, and all the more reason to get things right. But that's the first one in April 2026 that will be coming into place. The next is that day one right to paternity leave and unpaid parental leave. So removing that 26-week sort of qualifying period that I touched on earlier. We also see some enhanced whistleblowing protections. Now, these aren't the amendments Alice was just talking about. These are some slightly different ones where it effectively is looking to extend whistleblowing protection to disclosures relating to sexual harassment. So disclosures relating to sexual harassment under the Employment Rights Bill will be considered to be protected disclosures for the whistleblowing purposes. And then the final ones, those changes relating to statutory sick pay. And again, just to be clear about that, that's based on the current changes. This isn't talking about those proposed amendments. It is the removal of a lower earnings limit that currently applies, as well as that waiting period, i.e. it's from the first sickness day, not the sort of effectively from the 4th day of sickness that the employee would become entitled to it. So that's the first sort of major round of changes. And then we have a bit of a sort of 6 months to, I guess, adjust and get our heads around those before we then go into October 2026, where we have the sort of next round. And again, that there is more than these, but I've just picked out the key ones. So we have fire and rehire restrictions in whatever form they come in. As I said, it's likely with the government backing everything, it will be that slightly diluted form. But watch this space. Like all of this, it's all the subject of ongoing consultations. But whatever form it takes, it's expected at the moment in October 2026. There's also some proposals surrounding the tightening of current tipping laws. They've all sort of been changed in the last year or so, and there's just some further tightening surrounding those, and that would come into place in October. And then the extension of the duty to prevent sexual harassment, and that's to be all reasonable steps. That's going to be updated and come into place in October 2026. And then finally, we have that time limit extension. This is when that's also anticipated to come in. So the change of from it being 3 months to bring the employment tribunal claims to that period of 6 months. On that time limit point as well, just to be clear, that will always, that there's no current sort of proposed change to the ACAS early conciliation process and the knock-on effect that can have to those time limits. So it will, whilst we say, it's being extended to 6 months, the reality is it can technically be longer than that, subject to any periods of ACAS early conciliation. So that side of things currently is unchanged, but it's that core sort of time limit we're looking at. Then the next date falls to 2027. We don't have more specific proposals at the moment than 2027. I would hazard a guess it will be, in the same thresholds of April or October. That's sort of a natural place for these things to fall. But again, as the consultation and process goes on, I'm sure we may get some more details here. And as we keep saying, watch this space. We'll sort of keep everyone up to date on that as and when any such announcements were to come about. But for 2027, we've got things like some new sort of provisions coming in, introducing gender pay gap and menopause action plans being required in certain sort of from employers. A power to enable specific regulations to specify steps that are considered reasonable when dealing with sexual harassment. I mean, that's going to be that's sort of broadening or going into a bit more depth on this all reasonable steps, but it will hopefully, if such regulations were then introduced to specify those steps, it hopefully gives employers a bit more of a steer and a guide as to what they could do. It can probably also make it a bit more difficult, because if you fail to take one of the specified steps, then it can probably make it easier for action to be successful against an employer. But either way, clarity hopefully would be forthcoming from that. There's also in 2027 proposed changes to the collective redundancy. So that this isn't, as I say, that increase to the protective award would already be in place, but this is to do with the collective consultation threshold, and it's effectively removing the making it so it's a company-wide view of the sort of when it's going to be triggered, rather than dealing with specific sites. And with a new threshold, but we don't know what that's likely to be. It's sort of anticipated perhaps it might be 50 or 100 employees, but again, we'll see as the consultations go on as to how that might look. We have the introduction to the changes I touched on earlier surrounding the flexible working right. So this need to explain sort of why we believe it's reasonable and requirement for the refusal to be reasonable. The changes in relation to bereavement leave, which we've sort of touched on, as well as that changes to the 0-hour contracts, as well as applying those measures to agency workers. And the final one that in 2027 that we're looking at here, and I should say the big one is this currently day one protection from unfair dismissal in whatever form it ends up taking, and it's the one that everyone's probably in many ways most interested in and waiting on to see how it actually transpires. It's probably going to be the one that gets the most media attention, I would have thought, as Alice was touching on. Yeah. It's going to be sort of very much ping-ponged about, and it's such a headline core term to the government that it's probably one they're going to want to fight and stand their ground on, because they don't want to be seen to probably go back on that. But yeah, so we'll see whatever form that comes in, but it's not until 2027 that we're expecting that to be introduced. So again, hopefully well ahead of that, we'll know exactly how it is going to look, and it will give a nice period of time for employers to probably start adopting new practices in preparation, so that actually when that trigger date comes into effect, you're in the best position you could possibly be in. So that's the current sort of roadmap for implementation, and that with that it sort of concludes the webinar for today in terms of the core content. So as mentioned at the start, this is really the biggest changes we're going to be seeing sort of for a long time. This is employment rights bill is massive for us, and it's still developing and will continue to develop as it goes through Parliament. So as always, and as we've said multiple times, as a firm, as an employment team here, we're going to continue to keep sort of everyone updated on it. We'll probably be doing further webinars on the topics as and when that is appropriate. If you're on LinkedIn. You know, various members of our team will often keep, you know, people updated on any news and announcements as well, and would like to do articles. So just watch, I say this space, but all that space, for updates as and when they happen. So that is, as I say, that the sort of core content. I don't believe there's any particular questions at the moment. So as we wrap up, what I'm going to do is just move on to a slide here just with Alice and my details. If you had any specific questions, feel free to connect to either of us, both of us, whichever, on LinkedIn. You've got our email details on the slides. You're more than welcome to reach out directly to Alice or I. We'd be happy to hear from you. So otherwise, though, what we'll, as I said, tomorrow or early next week, we'll look to follow up. We'll provide you with a copy of these slides, so you've got that information, details of those changes and everything for your records, and everything's being recorded. So providing all that from a sort of tech side of things comes out okay and we're able to, we will also be including a copy of that recording within the follow-up for your record. So thank you everyone for joining us. And yeah, you know, we'll have a further webinar, will be circulated, the details of which will be circulated in our mailers and things like that for next month. So hopefully people can join us then. All right, thank you very much, everyone.
Thanks.